This is continuous coverage.
Continuous coverage.
In the trial of Lori Vallow Daybell from the Hidden Killers podcast.
We are at jury selection of day number 3 and segment number 4. Let's go to the courtroom.
Okay, we are back on the record. Case CR 2221-1624, State versus Lori Noreen Vallow. We had a lunch recess. We're resuming voir dire of today's second group of jurors. The court has reviewed the seating chart and finds that the remaining jurors are all properly seated. And here, the court had just concluded its own voir dire examination. I'll note counsel's all present and the defendant is present as well. At this time, then, the court will pass the voir dire to the state to conduct any questioning you have at this time. Ms. Blake?
Thank you, ladies and gentlemen. I know this has been a long process. You were here last week and you're here again today, and we do appreciate you coming back as we're trying to get a jury ultimately selected in this case. To answer a question that may be on some of your minds, because it's not often that you hear about 2 elected prosecutors being involved in the same case. So in case anyone's wondering that, we do have both Madison County and Fremont County here. As you heard, we both have fairly small offices. And as you may recall from when the judge read the indictment in this matter, parts of these crimes are alleged to have occurred in both Fremont and Madison County. So for those reasons, the offices have joined together in this prosecution. So in case anyone was wondering, thinking that was a little bit odd, I just wanted to let everyone know that. The judge went over this, but I just want to remind you, as we're going through the questioning process with you, so both the state and the defense, and the judge and the court for that matter, if at any point you feel uncomfortable with a question asked, you feel like you would rather talk about it outside of the purview of others, please let us know. There may be topics that we touch on that are somewhat uncomfortable. There's a reason that we're doing it, and we'll talk about that. But please don't hesitate to raise your hand. And the reason for that is we do want to make sure that we have all the information that may be necessary. If there's something that you feel the parties may know that could affect your ability, or you have concerns about serving, that's what we want to hear. And so please don't hesitate to do that. And that leads into part of what we're going to ask you to do today. If I use the term brutal honesty, I want you to think about what that means to you. And juror 1631, I'm going to ask you, if you hear the term brutal honesty, what comes to mind, or what would that mean to you?
To me, it means telling the truth regardless of consequences.
And juror 1265, I'll ask you the same question. If I use the term brutal honesty, what does that mean to you?
Just be truthful no matter what's at stake or hurting someone's feelings. Just be honest.
Okay. And I think those were both very consistent answers, and that's what I want you to think about. Is sometimes we may say things, we may believe things, and we may try to spare others' feelings. We may worry about how it's going to make us appear. But throughout this process, we are going to ask you all to be brutally honest. Can everyone here commit to be brutally honest? Does anyone have any concerns? Looks like everyone indicated that they can be brutally honest. And the reason we talk about that as well is I want to give you an analogy here. Have all of you flown on a plane before? So when you get on the plane, the pilot comes over the intercom usually and tells you an approximate arrival time, may tell you, it might be a bumpy ride, but that they'll get you there and you should land at about whatever time it may be. And you can sit back and enjoy the flight. If instead of that, the pilot got on and said, hey, I'm going to do my best to land the plane, we might get there at this time, would anyone here feel comfortable staying on that plane? And if you were given 2 choices, you have one pilot that tells you, I can land this plane, no problem, and one that says, I'm going to do my best. Which flight are you going to get on? The first one with the pilot that can land it? Would we all agree that's the flight we'd take? So that comes into play here because essentially you are all going to be like the pilot. You are going to be asked to follow instructions given by the court and only the court. So at times we may hear of a law or we may hear an element of a crime that we disagree with. We might think this seems silly or this isn't how it should be. And we need to make sure that everyone can commit, not say, I think I can. So similar to I think I can land the plane, not I think I can follow the instruction. We want to make sure that everyone can commit, yes, I can follow the instruction. And the reason for that is that both parties here deserve a fair trial. Both Ms. Vallow Daybell and the state of Idaho that represents the citizens both deserve the right to a fair trial. And in order to ensure that, we need to make sure that all jurors can commit to following the instructions as given by the court. Does anyone have concerns with their ability to follow the instructions given by the court, even if you may disagree with it? Looks like everyone answered no, that they would not have a problem doing that. Does anyone here believe that everything we see on the internet or the news is 100% accurate? I think everyone answered no. And juror 1621. Why would you not believe everything on the internet is 100% accurate?
It could be political, like leaning more to the left or leaning more to the right. It could be someone wanting to tell misinformation for their own agenda.
Okay. All right, thank you. So different people may have different agendas or different viewpoints. Would you agree with that?
Yes.
And so that information may not line up with what you would consider to be accurate.
I like to do my own research and form my own opinion.
Okay. So you don't just accept what the media puts out as fact. You like to go and research it yourself and form your own opinion?
Yes.
Okay. And I'll ask juror 1465. And why do you not believe everything on the internet or in the news?
If you listen the next day, it's different. So many untruths are being told.
Okay, thank you. And we're going to touch more on publicity later, and I think the judge let you know that'll be done separate and individual voir dire. With the next thing I want to talk about a little bit is the nature of this case. And again, the court touched on this. Just want to follow up a little bit. This is a case in which you are going to hear about the murders of 2 children and a mother of 5. Knowing that you are going to hear information and evidence regarding those things, does that cause anyone concerns about their ability to sit on a jury in this matter? Some of the evidence may not be the easiest to view in this case, and you were asked on the questionnaire about the potential to review some disturbing images. Knowing that there may be some evidence that's difficult to look at and that you may have a reaction to, which it's normal to have a reaction, does anyone have concerns that their reaction would be such that it would overcome their reason and common sense? And juror 1535. I believe you have some children, is that correct?
I do.
And if you were to see some photos depicting children, would that, and maybe some graphic photos, would that cause you concern?
Yes, it would cause me concern.
Do you believe that you would have a reaction to that?
Probably internally, yeah. It would make me feel uneasy.
Okay. With that, though, do you believe that if you were shown that and you were also presented other evidence, do you believe that you would be able to set aside any reaction you may have and give all of the evidence, every piece, the weight that it's due?
I would be able to do that, yes.
Do you feel like it would affect your ability to be fair and impartial simply because you may have a reaction?
No.
Okay, thank you. And I'm going to ask juror 1462. I believe you also have some children that are older now.
Yes.
Same question for you. Do you feel that it would cause you concern to the point that it would overcome your common sense and reason if you were to be shown some photos of children?
It would certainly cause me a lot of concern. I don't think it would overcome my common sense.
And do you believe that you could still listen to all the evidence presented and give all of the evidence the weight you think it's due and be fair and impartial?
I could certainly try.
And we talked about the pilot analogy. So do you believe that your reaction would be such that it would absolutely overcome your common sense and reason?
If what we were presented was extremely graphic, it could.
Ms. Blake, on this topic, I think it needs to be asked if you'd look at her answer to question 13 on page 9.
Yes.
Thank you.
And I think in your questionnaire and what the judge is just referencing is you had indicated that blood makes you nauseous and that it may make you likely to faint.
Yes, it does. I can't watch people draw blood or anything like that.
So, and when you say you can't watch people draw blood, that would be if you were there in person actually watching it.
Correct.
Have you ever watched a movie or seen photos in which blood is shown?
I try to avoid them. Otherwise, I pretty much hide my eyes.
If there have been times that you've caught glimpses in a movie or through photos, has it actually caused you to faint?
Not since I was a child.
So as an adult, you've been able to view those images. While upsetting, it hasn't caused you to faint.
Yes.
Do you believe if you were to be shown images that weren't something that you really wanted to see, would you still be able to view them?
Yeah, I'd be uncomfortable, but I could view them.
And I think it's normal to be uncomfortable. So then the question would be, would that uncomfortableness make it so that you could not view other evidence and fairly weigh all the evidence presented?
No, I think I could do that.
Thank you. And I'll ask juror 1628. I believe you also have some children.
Yes, ma'am.
And do you feel that viewing images that may be unpleasant to view involving children would cause such a reaction in you that it would overcome your common sense and reason?
I think it would be distressing, but I think I'm a pretty level-headed person overall.
So do you think that you could view evidence of that nature and give it the fair weight due along with other evidence presented in reaching a fair and impartial verdict?
Yes, ma'am.
Thank you. And the reason we go over some of this stuff is, like I said, and I just want to reiterate, all parties are entitled to a fair and impartial trial, and that goes for both Ms. Vallow Daybell and the state of Idaho. So that's why we go through these questions with you, just to make sure that we are selecting a jury that can be fair and impartial. So with that, I'm going to turn things over to Ms. Smith with the state for some further questions. Thank you all for your time.
Good afternoon. Thanks. I'm going to spend just a couple minutes following up on some things in some questionnaires involving some making sure that there isn't a misunderstanding of or some ideas that are floating out there that as to the law, and making sure we can all follow the court's instructions, because the law, as Ms. Blake has said and the court has said, is given to you by the court. I just wanted to follow up just a little bit. Let me start with juror 1628. Ma'am, I noticed from your questionnaire that both your mother and your stepfather were parole officers?
Retired parole officers.
Okay. And I understand from looking at that questionnaire that they were parole officers for several years?
Yes, ma'am.
Okay.
Yes, ma'am.
Okay, thanks. And ma'am, did you ever discuss their employment with them?
Just maybe overall, never any specific people, just general impressions and things that they would experience.
Okay. Now, sometimes people who have experience with the system and or their families, they hear stories or they hear about things out there. Let me just ask a quick question. You understand in this case, as the court has read to you, that the state of Idaho, the people of the state of Idaho, bear the burden of proof, correct?
Yes, ma'am.
Okay. Only the people of the state of Idaho, the prosecutors, have any responsibilities to prove anything.
Yes, ma'am.
Okay. And those responsibilities extend to every part of every charge. Does that make sense?
Yes.
The court will provide you the instructions, and they will have definitions in them, kind of parts. And there'll be multiple parts, and the people of the state of Idaho have to prove each one of those parts beyond a reasonable doubt.
Yes, ma'am.
Okay? You understand that Ms. Vallow Daybell doesn't have to prove a thing.
Yes, ma'am.
And if the state fails to prove its burden beyond a reasonable doubt of even one part of a charge, the jurors must find Ms. Vallow Daybell not guilty of that charge.
Yes, ma'am.
Okay. Is there anything about conversations or impressions or stories that you've heard from your parents that would make it hard for you to hold the state to its burden of proof?
No, ma'am.
Okay. Is there anything about any conversations you might have had with them, any impressions they had of their caseload that's going to make you're going to hold against Ms. Vallow Daybell?
No, ma'am.
Okay. What about anything about that those conversations, those impressions that you would hold against the state of Idaho?
No, ma'am.
Okay. You understand people deserve to be judged based on only evidence in this courtroom, right?
Yes.
And anything that you might have heard, because we all come into situations with ideas or opinions and even sometimes biases, right? Right?
Yes.
The question is, can the people in that jury box put those things aside and give both sides a clean slate, a fair trial? Does that make sense?
Yes, ma'am.
Is there anything about either your conversations with your parents or things that you have heard in this, in this process that's going to make it difficult for you to do your duty to both sides?
No, ma'am.
Okay. Thank you, ma'am. Now I'm going to ask you all to listen to my conversations with jurors because I'm not going to ask every time, does anybody have a reaction to that? But the idea is we learn from each other. And if there is something like Ms. Blake said, if there's something that triggers, only you know what's going on in your head. And it's too important to Ms. Vallow Daybell and to the people of Idaho that you tell us. We aren't clairvoyant. Okay? All right. Juror 1465. Yes, ma'am. I believe I read that your granddaughter is a deputy attorney general?
Yes.
Does she do, and I think she said she prosecuted cases?
She has in Oregon.
Okay, in Oregon.
Uh-huh.
In the state of Idaho, however, is she doing prosecution or is she doing civil?
I honestly don't know.
Okay. And perhaps we can, and I don't remember, and I'm going to ask one of my colleagues to double check if we have her name. What we might do is, at a break, Your Honor, we may want to inquire as to that name, given some other issues on this case, just to be safe. Okay. All right. So we'll circle back on that. But in terms of generally talking to her about her job, have you had conversations about cases that she's prosecuted?
I have heard of cases in Oregon after the fact, whether she lost or won, pretty much. But she doesn't discuss her cases with me.
Okay. Is there anything about those conversations that gives you hesitation about your ability to judge this case?
Not at all.
Okay. Did you get that, ma'am? Okay, I just want to make sure. We have to take turns, and I want to make sure I'm being fair to her. She can't take us both down at the same time. So, all right. Now, ma'am, is there anything about the fact that your granddaughter was once a prosecutor or may remain a prosecutor that's going to cause you to make it easier on the state of Idaho?
No.
Okay. Or anything you're going to hold against or in any way influence your opinion or your evaluation of the evidence with regard to Ms. Vallow Daybell?
No, I will listen with an open mind.
Okay, thank you. Juror 1265, sir. I noticed on your questionnaire you talked about real evidence. You understand that the court is going to give you an instruction on what types of evidence you can consider and the weight you give those, right?
Yes.
Okay. And that the court is going to provide you all of the instructions on that.
Yes.
Right. If the court's instructions discussed your ability under the law to evaluate circumstantial evidence, okay?
Okay.
And given in sight of your real evidence, that's why I want to follow up on this with you. Let me do this. I believe you have children?
Yes.
Okay. If you walked into the kitchen and you had told all the kids, do not open the cookie jar, do not eat the cookies, they're for dessert, don't touch them.
Okay.
And one of them, no matter how cute they are, is standing there. They got crumbs on the front. They got chocolate around their mouth. They got chocolate in their teeth, and their hands have crumbs on them.
Okay.
Okay? You with me?
Yeah.
But they don't say a word. Are you going to be, is your reason and common sense going to lead you to the conclusion that they ate the cookies? And cookies are missing, by the way.
It's going to cause me to ask them probably first what happened to, it looked like you had the cookies, yes.
Right. And so you're going to, on your reason and common sense, you're going to have a belief that they ate those cookies, right?
Yes.
Okay. That's called circumstances, right? And so that is evidence the same way as, say, a fingerprint or DNA.
Okay.
Does that make sense?
Yeah.
Okay. So in your discussion on, and the court is going to give you those instructions that we talked about. He's going to tell you that we have to prove each one of those things beyond a reasonable doubt.
Yes.
Okay. And I keep saying that because that's the state's burden and we welcome it. That's our job and we're okay with that. And I really want to make sure everybody understands that. Okay. Yeah. But he's going to tell you we have to prove each parts of those definitions beyond a reasonable doubt. But he's not going to tell you how we have to do it.
Yeah.
He's not going to give you a formula. He's not going to say you got to give a certain type of evidence in order to convict somebody.
Right.
Right. In fact, jurors can even, under the instructions, consider convicting somebody based on circumstantial evidence alone.
Okay.
Okay. Given your comments about real evidence, I just want to make sure if the state proved to you beyond a reasonable doubt all parts of a definition, so that your reason and common sense leads you to believe we've proven each of those parts, but the evidence you saw was only circumstantial evidence, but you believed each part.
Yes.
Could you still consider convicting somebody if all you saw was circumstantial evidence?
Yes, and my real evidence was for what was presented in the courtroom, not something that somebody had talked about outside. So that's what I meant by real evidence.
Excellent. Thank you. I just wanted to make sure. I appreciate that.
Yeah.
Did all the jurors, I thought I saw juror 1621 kind of look up when I talked about circumstantial evidence in that conversation. Juror 1621, did you have any thoughts on that? Or what's your let me do it this way. What's your reaction to that conversation?
Could I get the definition of circumstantial?
Well, let's use the cookie jar analogy without getting into definitions of the law because I don't want to do anything that would violate the court's order. But let's say you're in the kitchen and you see children and they've been told stay away from the cookies, and then there's crumbs, there's the chocolate on the fingers, there's the chocolate on the mouth, cookies are missing. Those are circumstances. Does that make sense?
Yes.
Okay. Could you, if the state were to prove each part of the definition to you beyond a reasonable doubt, but the state only supplied circumstantial evidence to you? Okay. They didn't produce an eyewitness, but they produced circumstances that led your reason and common sense to believe each part had been proven beyond a reasonable doubt. Could you consider convicting somebody with circumstantial evidence?
Yes.
Was there hesitation, or you just...
No hesitation.
Okay. Anyone else have a reaction to that? Okay. Thank you, sir. Back to juror 1265, sir. I see you're a marriage coach.
Yes.
Is that your profession?
Yes.
Okay. Have you taken any criminal justice courses, psychiatry, psychology courses?
None.
Okay. Have you ever had to be involved in a court suit involved in any of your practice?
None.
Okay. So never got drugged in the family court?
No.
Good.
It's a fairly new coaching business.
Oh, cool. Okay. And is that a faith-based coaching practice?
It has faith-based options, but you don't have to have faith to go through it, yes.
Understood. And so I anticipate, let's talk a little bit about witness credibility, if we could,
Sure.
With regard to that. Jurors are required to evaluate the testimony of people in a courtroom based on their answers, perhaps considering their training, their background. Does that make sense?
Yes.
And it is possible you will hear evidence about a witness's sort of religious beliefs. Now, it is certainly something you can consider in assessing their credibility on whether you believe them or not. But the question becomes, if somebody's religious beliefs were different than your own, or you were to conclude they were strange, or you thought it unusual, is the fact that they had religious beliefs or thoughts or faith that's different than your own and that you think might be a little odd going to make you automatically disbelieve someone?
No.
Okay. And there are people who have such strong faith that they really just can't assess someone. Is there any way that you have any of those concerns?
Not at all.
Okay. Did anyone else have a reaction to that? Okay. I believe I'm done. One moment. Let me check with my team if I may, Judge.
Yes.
Thanks.
All right. At this time, then, the defense may be allowed to conduct their voir dire. Mr. Thomas.
Good afternoon. Just have a few questions. I'm probably not going to be as long-winded as I have been in the past, so because the prosecution and the judge have asked a lot of the questions I'm going to ask. But I do have a couple of follow-ups. Let's see, juror number 1462. You've indicated that that you have blood kind of makes you nauseous and likely to faint, but then you indicated that happened since when you were a kid, right?
It still makes me nauseous, so I tend to avoid it.
Okay. I'm going to be honest with you. There's going to be quite a bit of evidence that you're going to hear about, you're going to see. There's some pretty gruesome things. Is that going to be hard for you to step? Because we don't want you to come in and be part of the jury and then say, "Gee, man, I can't look at that picture," or "I can't hear that evidence because it's and I'm trying to block it out," or because I think you said something about you just try to, when there's a movie or something, you just try to hide your eyes or whatever. That's not going to be an option for you. You see what I'm saying?
Yeah. That could be a problem.
Yeah. Okay. And while we want you to be on the jury, we want everybody to have their day in court, and we want everybody to be able to serve. Maybe this isn't the right trial for you, right?
Yeah, could be.
Okay.
The last one I did, there was no blood.
Yeah. Based on that, Your Honor, I'm going to ask the court to challenge this juror for cause.
Okay, let me ask a follow-up question or two of my own for this particular juror, 1462. It's, I think, been pretty well explained that nobody's expected to like to see those images. The question is whether you would be able to view them if you needed to. And I'll note there could be some accommodation. For example, if somebody needed to take a break for a moment, we could do that. So I just want to let you know the court can make things as comfortable as possible, but absolutely you need to give your full attention and view that type of evidence if it's presented. So that's what I wanted to clarify in terms of how the process would work. Given that, do you feel like it would just be too uncomfortable for you to maybe remain level-headed and clear-thinking if you're exposed to that?
I believe I could remain level-headed. I would be very uncomfortable. I might wish for one of those sacks from the airlines.
Okay. Mr. Thomas, I asked my questions. I'll let you ask any follow-up in the state as well before we make a decision on this issue.
Thank you, Your Honor. And so I know the judge said he's going to be able to make some accommodations, and I'm certainly not speaking for the court or for the judge, but some of this evidence is going to go back into the jury room with you, and you'll be talking about it with the other jurors, and you'll be looking at it, and I want you to be able to face it head on and go, yeah, I'm looking at body parts, and I'm having to focus on that and decide those kinds of things. I mean, that's going to be a reality for you. So I'm asking you honestly, just if you feel like that's not going to be something that you can do, help me out.
Yeah, that would be very, very hard. Yeah, that might be something I cannot do.
Okay. I would renew my challenge, Judge.
Okay. Any response from the state?
Yes, Your Honor. So I know we've spent a lot of time on this issue with you, and I think specifically in your questionnaire you talked about blood, and you and I talked about seeing blood in person versus photos or a movie.
Yeah.
And the judge talked about some accommodations. Mm-hmm. So if you needed to take a break. So I think the question is, could you view the evidence and still give that evidence the weight you believe it's due while still listening to the other evidence and giving that evidence the weight it's due? Do you feel that you could equally or weigh the evidence to the extent you thought that evidence needed to be weighed and render a fair and impartial verdict?
Yes, I could.
Thank you. Judge, we would object.
All right. The court's considered the challenge here. I'll note we've gone through a lot of jurors in this process, and this one in particular, I think, has been able to express the greatest concern probably of anyone we've talked to is when it comes to that nature of evidence. Some people are more susceptible to perhaps being traumatized by that type of evidence than others, and I do think that with some of her questions it's raised enough of a concern for the court that it would likely result in an undue hardship for this particular juror to be able to sit on this case in light of what the parties are representing the evidence may be. So for that reason, I am going to sustain the challenge on Juror 1462 and consider that an excuse for hardship. So Juror 1462, thank you so much for your service. I'm glad you're such a kind-hearted person, and you can be excused from your service at this time. And as I mentioned to other jurors, if you wish to speak to others about your service here, you can do that, but respect the privacy and feelings of your fellow jurors. And if somebody persists in trying to talk to you, please report that to the court. All right, thank you. You can continue, Mr. Thomas.
Thank you, Your Honor. Juror number 1621. You have indicated on your questionnaire that you had heard about the case, and then it was basically on KTVB 10 p.m. news.
Yes.
Can you expand a little bit on what you've heard about the case?
I usually watch the news for the weather, but I've seen clips.
And Your Honor, I apologize, but I think we're getting into what the court wanted to take up in individual voir dire.
I agree. Let's save that for an individual voir dire, Mr. Thomas. Thank you.
I do have a couple other questions for you, though, okay? So we'll talk about that in a little bit. So you indicate that that this may be a hardship for you, the length of the trial being 8 weeks long. You have a full-time job, is that correct?
Correct.
Do you support a family?
I do not.
Okay, so it's just you?
I live with my family, my parents.
Okay, all right. And you indicated, I believe it said that you rent, so you pay your parents' rent?
Correct.
Okay. And not having to be able to pay, I'm assuming are you going to work while you're on jury duty?
No.
Okay. So having that 2-month period of where you wouldn't be able to pay rent or basically have any income, is that going to be a hardship for you?
No.
No? Okay. And have you talked to are you working right now?
Yes.
Have you talked to your employer about that?
My direct supervisor, yes.
Okay. And they're okay with you being here for 8 weeks?
Yes.
Okay. All right. Juror number 1628. Kind of has a similar line of questioning. You have a 3-year-old at home, is that right?
2.
A 2-year-old?
2
Or 2 3-year-olds. Twins?
Yes, sir.
That's awesome. My dad's a twin. That's pretty cool. Boy and a girl, or just 2 girls or boys?
Yes, sir. Boy and a girl.
Wow. That is amazing. I'm sure it's really hard, but it's pretty cool having an uncle and my father the same. And then you also indicated that you had some work obligations. Is that right?
Yes, sir.
Is that going to be a hardship for you? I mean, we don't necessarily want you to put yourself in a position where it's going to be a struggle on your family or on. We all have to work. I mean, we all have to make money. We understand that, and so is that going to be a hardship for you?
It's not ideal, but my employer is willing to work with me on it.
Okay, good. And is it a situation where you're going to be able to be compensated for the next 8 weeks, or is that something that you'll have to take vacation or uncompensated time?
My company offers paid jury time.
Okay.
To an extent.
Oh, but not for the full 8 weeks?
We would take it up with HR to ask for the extension. That's
Okay.
what my supervisor has said.
Okay. If you get selected?
Yes.
Okay. All right. You're currently in the Army, is that right?
Formerly.
Former. And it looks like you served in Germany?
Yes, sir.
I was born in Germany. Landstuhl Air Force Base. Thank you for your service.
Thank you.
Okay, I have no other questions for you. Thank you so much. Let's now turn to 1265. So we talked a little bit, or the prosecutor talked a little bit about your questionnaire. And your questionnaire, you said that if presented with real evidence, you would form a new opinion that was not media biased, right?
Yes.
And so,
Your Honor, again, I worry that we're headed down, with the mention of media, I worry that we're headed into what the court has indicated will take up an individual voir dire.
Well, we're fine for now. Just don't elicit any specific comments about the exposure, and I'll ask the juror to do the same. So just answer in general terms, please.
sure. And I'll just bring up that the state brought this specific question up already.
I understand. So you can continue.
All right. So what sort of real evidence would you need to be presented with?
The evidence that was brought forth in this trial.
Okay. So would you need the defendant to bring some evidence?
No.
No?
No.
Okay. But you've indicated that you've already made some sort of an opinion. You've already had an opinion about Lori Vallow, right?
Correct, yes.
Okay.
I mean, yeah, to a certain extent, sure.
Yeah.
I don't know much about this case other than the years ago I work at home. Like what I used to do was in-home sales for remodeling, and people would have media on, like just, on their TVs or whatever. And so occasionally people would be talking about it when it was in the news. Mm-hmm. And my only opinion I ever formed was, I think someone was maybe referring to it in a negative light, and I just said, yeah, that it, circumstantially, didn't look great. That was the only opinion I ever formed.
Didn't look good.
Didn't look good.
Right. Okay. Okay, thanks. 1465. How are you today? Good. So, how do I put this? You're at an age where you can be excused based on your age. Is that something that you want to do? Do you want to be on the jury?
I'm happy to serve.
Happy to serve. Okay, good. Right? Okay. So it's not going to be a hardship for you to be here? Okay. All right. Good. I just want to give you that out. $15.35. How are you doing? Good. So I looked through your questionnaire, and it didn't look like you had any exposure as to who Ms. Daybell is, correct?
Correct.
So you've never heard of her before you came into jury duty?
I never heard. I just moved here a year ago.
Oh, really? From where?
What's that?
From where?
Oh, California.
Oh, okay. Where in California?
Los Angeles.
Okay. All right. Well, welcome. That's all I have, Judge.
All right. Thank you, Mr. Thomas. All right, counsel, we will next go into individual voir dire. Before we do that, I'd like you to look at the questionnaires again for jurors 1465, 1535, 1628, and 1631. As I review those, I don't know that there's a need for individual voir dire for those jurors, but if there is, please let me know what it is, so I'll give you a moment to look at those 4 questionnaires again. Yes. 1465, 1535, 1628, 1631.
And Judge, if we're talking about for individual voir dire, and especially with the media, I think the only one the state would wonder is 1621, just based on one comment on the questionnaire, maybe just a little bit of follow-up. And it's just talking about news sources watched, if the court's wondering. We just wanted to clarify a few things based on that.
Okay, the four I identified, I thought didn't express anything that required individual voir dire. So you think 1621 fits in that as well?
I think that does. Just some brief follow-up.
I guess I'm confused now. So you do or do not want individual voir dire on 1621?
Yes, we did think that one. We think the other numbers read by the court would not require individual voir dire.
Okay.
Given the court's admonishment to me about going into other things, I would just ask to be able to individually voir dire everybody on the panel about the media.
Well, I think I can help make that a little more efficient by asking some general questions to those jurors. They've all indicated, the four I read at least, no exposure at all, and I think they can just be asked whether that still continues to be the case. So, give me a moment. So 1265 and 1535 both have expressed. Oh, I'm sorry, 1535 is not on there, so I guess it's just 1265 certainly would require individual voir dire, know something about the case. The others then, let me just ask you as a group. In your questionnaires, you all indicated essentially you just didn't know anything about the case. So if you put that in your questionnaire, other than what was advised of you in court when you came in to fill out your questionnaires and today, other than that, is it still correct that you don't have any information about this case?
Yes.
Okay, let me just go down the list. I probably have somewhat lost track now, but 1265, I wouldn't ask you because you've indicated you do, and we'll talk to you about that. 1465, is that correct? That you don't know anything about this case and didn't? No. So that's correct?
That's correct.
Okay.
Sorry.
All right. 1535, is that correct?
That's right.
I think 1621 is, I had a question. Okay, 1621 we would talk to individually, and so then for juror 1628, is it correct you just didn't know anything about this case until you came for jury duty? Okay, and I'll ask finally for 1631, is it also correct you didn't know anything about the case until you reported for jury duty?
Right.
Okay. Well, counsel, I don't see a need for individual voir dire on them unless there are other topics, and if you want to have any final probing question on that, Mr. Thomas or the state, I'll allow it because I don't see a risk of going into any detail here, and we'll certainly reserve the other two for individual voir dire. So do you have any follow-up questions, Mr.
I do.
Thomas? Okay.
1628, you indicate that you have 2 2-year-olds, twins. Do you have any social media that you normally go on?
I'm on Instagram and Facebook.
Instagram and Facebook. And you've never seen anything scroll by about this case?
No, sir.
You've never seen a YouTube video on it?
No, sir.
Never saw anything come up on the news?
I don't watch the news.
Okay. Nothing further.
Okay. Does the state have any follow-up voir dire before we go to individual?
No, Your Honor.
Okay. So give me just a moment again to get organized here. All right, we'll be talking individually to jurors 1265 and 1621. Let me go through the others that I've got here and ask then, on juror 1465, does the state pass that juror for cause?
Yes, Your Honor.
Does the defense? Okay, juror 1465 has been passed for cause, so we won't do individual voir dire with them. Juror number 1535, does the state pass that juror for cause?
Yes.
Does the defense as well?
Yes, Your Honor.
Okay, juror 1535 has been passed for cause. Juror 1628, does the state pass that juror for cause?
Yes, Your Honor.
Does the defense pass that juror for cause?
Yes, Your Honor.
All right, juror 1628 is passed for cause, and juror 1631, does the state pass that juror for cause?
Yes, Your Honor.
Does the defense pass juror 1631 for cause?
Yes, Your Honor.
Okay, so we will have all of those jurors, we'll have everybody except juror number 1265 retire to the jury room, and we will individually conduct questions with juror 1265, and then we'll come back to 1621 after that. If all would please rise for the jury. Thank you. Please be seated. All right, juror 1265, first of all, I want to let you know you're not in trouble for being here as the only juror sitting there right now.
Just telling the truth, so.
Sure. Hey, everybody is entitled to watch the news as much as they want, follow whatever stories they want. There's absolutely nothing wrong with that. Many people do. This case has garnered a lot of media attention and pretrial publicity, and so we need to inquire as to whether or not that's affected somebody in such a way that they should not be serving in this case. So a few preliminary questions I'll have for you. First, before you came in and reported for jury duty last week to get your questionnaire, were you at all aware of what charges had been filed in this case against the defendant, either here or anywhere else?
No, I completely forgot about this case.
Okay. Thinking back now, well, that answers that question. The next question I would have then is, at any time in the past, do you recall watching any kind of a news program or special dedicated to this case, like a 48 Hours or Dateline or some documentary or made-for-TV movie or anything like that?
No.
All right, that'll conclude my questions for this particular juror then. Does the state have any individual voir dire for juror 1265?
Briefly, Your Honor.
Juror 1265. Okay. You understand that anyone brought in before the court has a presumption of innocence, right?
Yes.
And that the jurors in any case have to only judge the evidence that is presented from the witness stand or allowed in court by Judge Boyce in this particular case.
Yes.
Okay. Is there anything about what you saw on the news or you saw other places that you're going to be thinking about while somebody's testifying on that stand?
Nothing at all.
Is there anything about that you're going to be thinking about when you're trying to decide whether the state proved its case beyond a reasonable doubt?
No, the defendant deserves a fair trial. I 100% believe that.
Okay. And so there were some remarks in your questionnaire about, seeming suspicious or along those lines. Is that an opinion that would affect your assessment of the evidence in this case?
No, I can be 100% objective in this case.
Okay, because you recognize, I'm just being really blunt, you recognize how important it is to both sides.
100%.
Okay, and anything that you could think of, you're not going to be doing a compare, like I saw this here, what does it look like in courtroom? There's no compare contrast?
No.
Okay, thank you.
All right, thank you, Ms. Smith. Mr. Thomas, you can inquire.
Thank you, Your Honor. On your questionnaire, you indicated, the question was, what have you heard or what do you know about the defendant, Lori Daybell? And you said, dead spouse, comma, children found dead, comma, on the run. So what did you mean by dead spouse?
I think I remember something about, it was, I said that my details are foggy on that. That's what I was going off of, what I think I remember. And it was something about a spouse no longer being there and missing children. And then the last I remember seeing about the case at all was that the defendant was found in another place. I don't remember specifically even where that was.
So our problem is that you have things in your mind that may not be percolating up to the top. But as we put on 200 witnesses, those memories are going to come flooding back, and you're going to hear things that maybe are consistent, some are inconsistent, and so you're going to have to weave this whole thing. So when I'm asking about the dead spouse, which dead spouse? Who's dead spouse? Do you know?
I do not remember.
Okay. Children found dead. What about that? What do you remember about that?
I don't have a lot of memory on that. I just remember hearing that children had passed away.
Whose children?
I believe what I remember was the defendant's.
Okay. And how many kids were there? Do you know?
I don't remember. 2 or 3.
All right. And you're not sure if it was the defendant's dead spouse or somebody else's dead spouse?
I am not 100% on that.
Okay. On the run, what was that about?
That might have been commentary at the time from maybe a person that was around me. So I was just answering what came to mind when I thought of it. That children were missing, and that the defendant they had been looking for the defendant, I think.
Okay. Anything about the kids? Anything else about the kids?
No.
That you remember?
Not at all.
Just that they were dead.
Yeah, I remember them being missing, and I remember someone saying that they had been found dead.
Okay. Do you remember where they were found dead?
No, I do not.
What kind of social media do you follow?
I'm on all forms.
All forms?
Yes.
Facebook?
Yep.
Do you get on YouTube?
Yep.
Instagram?
Yep.
TikTok?
Yes.
And none of those things had any kind of a feed where you heard anything about the defendant?
I have completely forgot about this case until Monday when he said the name.
And you don't remember where she ran off to?
No.
Okay. Well, last week when you filled out
I might have said Hawaii. That state is coming to mind. I don't know.
So last week you remembered it was Hawaii, and then I just asked you where it was, and now you don't remember, but now you're saying it might be Hawaii.
Yeah. I'm just, as I said, I don't have a lot of memory of this case. And I was never intently ever watching it. It was background and commentary from people that I was around in their homes.
Uh-huh. And you indicate, it says, has any of your possible exposure to the news reports, dramatized depictions, or publicity around the case caused you to form an opinion about Lori Daybell? And you said yes. I just remember thinking, Why would she be in Hawaii if her kids are missing?
Sure.
Do you remember that?
Sure.
Okay. Can you expound on that a little bit?
I think that's just what that didn't look good if she was in Hawaii when her kids were missing. That's what I remember thinking.
Yeah. And that's what you formed an opinion like, hey, she probably killed these kids.
I did not form that opinion. I just remember that didn't look good.
So that was the opinion that didn't look good.
Correct.
Okay. And then the next question is, you indicated if you were presented with real evidence, you'd form a new opinion, not media biased.
Correct.
Okay. But you're admitting that you have been biased by the media?
I'm admitting that, yes, I had an opinion when I was in front of the media that had been played, and then, but I know that that's just what was played there, that none of that's real. I am not supposed to take any of that into account. I am only supposed to take into account what I hear and be completely honest with you. So that's what I'm doing.
Right. But you take with you all of your experiences of life, and some of those experiences of life are hearing other people talk about this case, right?
Sure.
And there were a lot of people that were talking about the case, right?
Sure.
Okay. Did you have any exposure before you came into jury duty, knowing from either the media or one of the social medias or one of the TV stations that, hey, this is a big case coming up, and man, your number got pulled?
I completely forgot about this case.
Completely forgot.
100%.
Okay. Your Honor, based on his answers today, I'm going to challenge this this juror for cause, indicating that he did indicate that he had a media bias, and that when some real evidence came in, he would form a new opinion, but he was biased by the media.
All right, what's the response from the state?
I think the juror's answer speaks for itself. He recognizes that whatever he saw out in the world or the internet or what somebody said wasn't real. And I think his question, in light of his explanations both to the state and to defense counsel, shows his absolute ability to put aside whatever things he might have heard and judge the case on what the court decides is real evidence admissible in this courtroom. Nothing about his answers indicate an inability to follow the court's instruction. Nothing about his answers suggests he can't be fair and impartial to both sides.
All right, thank you, Ms. Smith. Court's considered the challenge on Juror 1265 for bias. The concerns raised here, I find somewhat troubling. The response on page 11, question 2, reference to a dead spouse, which raises a concern for me. There's also the concerns raised about prior exposure to facts of the case, about forming a new opinion. The concern I also have is the juror indicating that he had forgotten things about the case, but is perhaps being reminded about things about the case. And I think it becomes unclear then whether or not, as evidence is presented, more memories may surface that may conflict with what's being seen in actual evidence. Under Idaho Code 19-2019-2, I have to consider whether or not there's some inference that a juror may not be able to act with what they call entire impartiality. And so, exercising caution here, Juror 1265 will be excused for cause. Again, Juror 1265, we appreciate your candor and your responses. We're just trying to get the best jury possible in this case, and I appreciate your service coming in today, as well as your time spent answering the questionnaire. And with that and the admonishment I've previously given jurors when they've left about communications, you can be excused. Thank you.
And Judge, before the next juror is brought in, can we approach?
Yes.
We'll have to unmute when they're done with the sidebar. judgment calls. I leave that in the room. When they go back, the judge comes back. Well, unmute it, but if I grab one of you guys, go first. I'll ask him to make sure. Judge, just a moment. May we unmute the live stream?
Okay, thank you.
The live stream is going again, Judge.
All right, thank you. At this time, I'll just have all of the remaining jurors brought back in as a group. Yes. They're coming in with the rest of the group, 1621. So, no, well, I'll just address them now. I don't need to talk to them individually. Okay, thank you. Okay, thank you. Please be seated. We're back on the record now on CR 2221-1624. We conducted individual voir dire of the jurors in this case. We were going to do that on juror 1621 upon further review of the questionnaire and in discussion with counsel in a brief sidebar. The state believes they've identified what would be an appropriate strike for cause for bias as to juror 1621. Is that correct, Ms. Blake?
That is correct, Your Honor.
All right. Does the defense join in the challenge for bias as to juror 1621? All right. The court did consider the responses in the questionnaire, and also looking at the standard I apply, I do find that there's a risk here that this particular juror may not be able to act with entire impartiality, and for those reasons, I'll find that the cause challenge of 1621 is sustained and juror 1621 will be excused. So for you, juror 1621, I'll just have you remain seated with the other jurors for a moment. You are excused from the case, and as you leave today, again, you're entitled to talk to anyone you want to about your jury service, but respect the feelings and privacy of your fellow jurors. If somebody persists in talking to you and you don't want to talk to them, then please report that to the court. For the other remaining jurors at this time, and just to make sure the record's clear, everyone but 1621, if you'd raise your red card at this time. So jurors 1, 4, 6, 5, 1, 5, 3, 5, 1, 6, 2, 8, and 1, 6, 3, 1. You have been passed for cause at this time, which means that you will be required to report again to court for the peremptory challenges, which will be exercised most likely later this week, and perhaps as soon as tomorrow. We'll have the final scheduling worked out as we go. You're instructed to contact the jury commissioner, or they will contact you, and you'll be given instructions as to when you are specifically required to return. We'll provide you with a business card for the jury commissioner so you have their contact information. I'll advise you that while you're waiting to be recalled to court, if you're approached, questioned, followed, or in any other way bothered, please report this to the court immediately upon your return. And also, you'll be required to again fill out that affirmation that between now and that time you do not conduct any sort of investigation in the case, don't look into the case. I realize the case is in the media a lot right now. If you see it come up on your device, on the computer, on the news, please don't watch anything about it so that you can maintain your impartiality that we've worked so hard to ensure you have getting to this point. After you return then, we'll go through the peremptories and you'll be advised at that time whether or not you remain to serve in the case. So I appreciate the service of everyone that's here today, and that will conclude the voir dire of this group of jurors. Is there anything else we need to bring up from the state before we release these jurors?
No, Your Honor. Thank you.
Anything else from the defense?
No, Your Honor.
Okay. Thank you, counsel. So all please rise for the jury. All right, let's take a brief break then, and we'll get the next group lined up. Does everybody want to agree on where we're at this point and make sure we're all tracking the number here? Because I think we're getting close to the number 42. Yeah. 39?
Yes.
All right, let's take a recess then, and we'll start up with another group of jurors and see where we land at that time. So I'll work with the marshals or bailiffs here to see how long it'll take to get them lined up and ready to go, and try to take a fairly brief recess here if possible.
And we'll compare notes to see how many we can agree on.
Okay, if you'll go through that, that's been very helpful. So you take your time to do that, and once you're ready and the jurors are ready, then we'll come back to the bench.
Lori Vallow, we're going to be taking a brief recess. Do you have an ETA on when the jurors are going?
All right, if we could have the next panel of jurors brought in, please.
Judge, would you like the live stream resumed?
Yes.
Did you see it?
You just told me.
Yeah.
All right, please. Panel's all present, Your Honor.
Okay, thank you. Please be seated. We are back on the record on case CR 22-21-1624, State versus Lori Vallow. We are conducting voir dire of individual groups of jurors. This is group number 3 for the day, and the jurors have been brought to the courtroom. The court notes that the prosecution is here. The defense also is present in court along with the defendant. And ladies and gentlemen of the jury, you've been returned here after completing your questionnaires for the court to determine whether or not you'll continue in the case or whether there's a challenge to your service based on any bias or hardship. So upon review of the questionnaires we have, the court has conferred with counsel and determined that certain of the jurors today should be excused for cause or for hardship. I'll first indicate that your time you've committed here is certainly welcome, and you've completed your jury service if that's the case. Also, I would advise you that upon being excused today, if don't feel offended or that somehow your integrity or honesty was challenged here. It's simply a matter of us trying to go through the process to get the most fair and impartial jury possible in this case, and that was the purpose of those questionnaires, which have been very helpful. We appreciate your candor and your responses. If you are excused, I'll give you another instruction as you leave. So at this time, the court will go through the list. We'll take a roll call in a moment and note a couple of jurors failed to appear, so we'll address that when we do the formal roll call. The jurors I'll address next, based on agreements between the parties, would be starting with juror red card number 15. That particular juror had expressed a concern about a hardship. The parties reviewed that and agreed that that juror should be excused based on a hardship. Does the state agree that juror 15 can be excused for that reason?
Yes, Your Honor.
Does the defense agree?
Yes.
Okay, juror 15 will be excused due to hardship. The next juror we'll look at is juror number 23. On juror number 23, the parties have reviewed the responses to the questionnaire, and it appears this juror was exposed to some pretrial information about the case that the parties believe would result in a possibility of bias in the case. So does the state move to challenge juror 23 based on those responses for bias?
Yes, Your Honor.
Does the defense concur in the challenge?
Yes.
Okay, the court has reviewed the questionnaire and also consider that juror number 23 should be excused based on bias. The next one we'll take up is juror number 184. For juror number 184, there was an indication that could I have a brief sidebar with counsel as it relates to 184, please? Okay, thank you. Thanks for clarifying, counsel. So as to juror 184, there is no challenge at this time to take up. The next one we'll call up then is juror number 250. The parties went through the questionnaire of juror 250 and found indications that they believe there may be a bias represented based on the responses. The courts reviewed that questionnaire as well. Does the state raise a challenge on juror 250 for the cause of bias?
Yes, Your Honor.
Does the defense concur in that challenge?
Yes.
Very well. Juror number 250 will be excused based on that reason. The next one we'll take up is juror number 274. On juror number 274's questionnaire also, the parties indicated a concern about potential bias in the case based on responses and pretrial publicity and exposure to the case. Does the state challenge juror number 274 for possible bias?
Yes, Your Honor.
Does the defense concur in that challenge?
Yes.
Very well. Juror number 274 will be excused as well for bias. Juror number 326. Juror number 326 indicated that while they thought they could serve here, there was still some concern the parties raised about whether or not this would create a hardship based on their personal circumstances. Does the state believe juror 326 should be excused due to hardship?
Yes, Your Honor.
Does the defense agree with that?
Yes.
Very well. The court's reviewed that questionnaire also and find good cause to find a hardship excuse requiring the excusal of juror 326. And then finally, juror number 389. After review of the responses in the questionnaire, the parties raised a concern regarding a possible bias in the case. And this juror has also seen information about the case indicated in those responses. Does the state believe juror 389 should be excused based on bias?
Yes, Your Honor.
Does the defense join in the challenge?
Yes.
Okay. The court concurs also that juror 389 would be excused based on bias. So, ladies and gentlemen of the jury, if I just called your juror number there, going through those questionnaires, jurors number 15, 23, 250, 274, 326, and 389. For each of you again, thank you so much for your time and service and reporting back here, for completing your duties as jurors in this case. If anybody wishes to talk to you about your jury service, you're free to do that. However, please respect the privacy and feelings of your fellow jurors and only discuss your own personal perceptions or feelings about your service here. If somebody wants to talk to you and you don't want to talk to them and they persist over your objections, then please report that to the court. And with that, you do have the sincere thanks of both the court and the counsel for both parties here in your service today, and you can be excused. So I'll have you go with the bailiffs at this time, and then we'll talk to the remaining jurors. All right, next I'd like to discuss an issue with juror number 116. So that's the gentleman, I'm sorry, I won't refer to you. That's just juror 116 in the top right there. We have requested that you complete these juror affirmations about whether or not you've refrained from looking into the case at all, and I was advised that you did not sign the affirmation. I'd like to question you regarding that. Did you intentionally decline to sign that for some reason?
I did, in that section D there, that paragraph D that talks about if someone else has talked to you about it. My wife is a crime junkie, so trying to get away from her when we both work from home is difficult, and trying to tell her to not talk about anything has been difficult for the last week.
Okay, and I understand the circumstance. You are not the first juror that's had this situation arise, and this is in particular why we have the juror affirmation. So first, I commend you on your honesty. It's exactly what we want people to do. Let me ask you a couple of follow-up questions. Were these conversations relating to this case since you came in and filled out your questionnaire?
Yes, sir.
All right. Did she discuss with you some facts and knowledge she had about the case that you didn't previously know?
No, but she's looking at the news and telling me how many jurors they selected on Monday. She's like, stop talking to me about this.
Okay.
So yeah, she's brought things to my attention, unfortunately, when I've asked her not to.
Do you think that situation will persist if you're here for 8 weeks serving on this jury?
If I'm allowed to go home, yes.
Well, I'll allow you to go home. And based on your answers, I do think that you should probably be disqualified from service for that situation. And again, it's not a personal thing. It's just us getting the most fair jury we can to go through the entire trial. Does the state have any objection to excusing Juror 116?
Not based on his answers, Your Honor.
Okay. Does the defense have any objection to him being excused?
No objection.
All right. Well, Juror 116, thank you for being honest and for reporting to the court what occurred. You can be excused with the same admonishment about communications I just told the other jurors, and thank you. Let me give you the rest of those admonishments. Did I give you the rest of the admonishments? Oh, okay. All right, at this time the court will commence with the voir dire of this group. Ladies and gentlemen, thank you for returning. You've all been recalled as prospective jurors in this case. I'll briefly reintroduce the case to you. I'm Judge Stephen W. Boyce from Fremont County, and I'm in charge of the courtroom in this trial. Here assisting today is a court clerk who will be administering oaths. The court reporter will be taking a stenographic record. The bailiffs are assisting with the jury, and my staff attorney will be assisting with legal issues that may arise. Each one of you is qualified to serve as a juror of this court, and we've reviewed now your questionnaires, so we will be following up with additional questions. At this time then, to keep the record clear, I would request that the court clerk conduct a roll call of those remaining jurors. So as your number is called, please hold that number up and indicate here if you're present.
Juror 1793. Juror 55. Juror 64. Juror 184. Juror 228. Juror 290.
Thank you. At this time, to assist you in understanding and participating in the jury selection process, I'll briefly reintroduce you to the parties and their lawyers at this time and summarize what this case is about. The state has brought this case, the state of Idaho. I'll sometimes refer to them as the prosecution. The state is represented at this trial by Lindsay Blake, who's the prosecutor for Fremont County, and by Rob Wood, who is the prosecutor for Madison County, and by specially appointed prosecutor Rachel Smith. The defendant in this case is Lori Vallow, and she's here represented by her attorneys Jim Archibald and by John Thomas. Thank you, counsel. This case is a criminal matter, which means that the defendant is charged by the state of Idaho with a violation of the law. I previously read to you a summary of the charges in the indictment. With regard to the defendant, the state of Idaho alleges that Lori Vallow Daybell committed the following crimes. Count 1, conspiracy to commit first-degree murder and grand theft by deception. Count 2, first-degree murder. Count 3, conspiracy to commit first-degree murder and grand theft by deception. Count 4, first-degree murder. Count 5, conspiracy to commit first-degree murder. And count 7, grand theft. The defendant has pled not guilty to all the charges. Please remember, this is simply a description of the charges, and it is not evidence. Under our law and system of justice, every defendant is presumed to be innocent. This means two things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove her innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crimes beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from a lack of evidence. If, after considering all the evidence, you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. I'll next discuss your duty as jurors. Your duty is to determine the facts and then apply the law set forth in the instructions I will later give you to those facts. In this way, you will decide the case. In applying the court's instructions as to the controlling law, you must follow those instructions regardless of your opinion of what the law is, or what the law should be, or what any lawyer may state the law to be. During the course of this trial, including the jury selection process, you are instructed that you are not to discuss this case among yourselves or with anyone else, including through the use of email, text messaging, tweeting, blogging, electronic bulletin boards, or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet. Do not form an opinion as to the merits of the case until after the case has been submitted to you for your determination. At this time, then, I would ask the jurors to please stand and raise your right hand, and the clerk will administer the oath.
This is continuous coverage
Continuous coverage.
in the trial of Lori Vallow Daybell from the Hidden Killers podcast.
Hidden Killers Podcast.
You've been listening to jury selection audio from the courtroom in the trial of Lori Vallow Daybell. We, of course, will be bringing you the courtroom audio as we get it, as this trial gets underway. I'm Tony Bruschi. Stay with us.